All right, so we're NYC Legal Geeks. We do a couple of talks like this a year. We teach classes for game developers, comic book creators, and occasionally attorneys. And we are going to be started off by Matt Versace, Vernacci, my apologies, making mistakes already. And he's going to be talking about trademarks.
All right, let's jump right into it.
Absolutely.
All right, so what is a trademark? It could be a lot of different things, but you think of it as branding, essentially, right? So that's the overarching concept. That could be a word, a slogan, even a sound, product or service packaging. We'll talk about that a little bit more, called trade dress, or it could be even a color in some instances. And the purpose of a trademark is to identify the source of goods or services, right? You see Microsoft's logo on something, you know that it is coming from Microsoft, right? And so there's that quality assurance aspect and this brand goodwill that you're associating with a particular word, a logo, things of that nature, right? So just keep them in the back of your head. Source identification. Why would you want to acquire a trademark? And that's, again, to build consumer goodwill. You want to know when you slap your studio's name on something that folks associate a certain level of quality with it, right? And they're not going to be confused with similar names, logos in the marketplace. And this, again, can be applied to both goods and services. It can be applied to a service mark for video game development services, right? If you're using a particular studio name, it could also be for a particular good or service, or a video game, a computer game. How do you acquire a trademark? You don't have to register a trademark. Lawyers usually recommend it because you have some bonus rights associated with it. But to acquire, you have to use the mark in commerce, and that just means using the mark in connection with selling goods or services to the public, right? Can't have private sales on the side. It has to be something that is directed to the public. Again, we'll talk about common law rights and registration, but registration essentially gives you additional damages in case there is an infringement suit. You have a place in line essentially when you register. So there's a lot of benefits that most attorneys would recommend. How long does a trademark registration last? It can last forever so long as, one, you continue to use the mark as registered. You can't be adding letters to your mark. You can't be calling them Nikes, right? If the mark is for Nike, it has to be the same mark. It has to be used as it's registered. You pay the maintenance fees, and you're ensuring, and we'll talk about enforcement in a second, you're ensuring that there's no dilution in the marketplace, that there aren't any other actors using a similar mark out there that are essentially confusing where the mark is coming from. All right. How do you assess the strength of a trademark? What's a good trademark name? So there's a sliding scale, and in trademark world, we call it distinctiveness. So at the lower end, and you want to avoid game names and logos that feature these types, generic, right? Just calling it what it is. The product is a video game, you're calling it capital V, capital G video game. Not going to get you trademark registration. Similar is if the mark is merely descriptive. If you're just describing the goods, kind of related to genericism. So just be careful with that. You want to try to find a mark that is at the suggestive, arbitrary, or fanciful level. So that could mean requiring imaginative leap, right? So electronic arts, right, doesn't really tell you exactly what the goods or services are, but you can kind of understand why it's like almost a little bit descriptive. So that's a good level of distinctiveness. It's a pretty good strength. Now compare that to fanciful, right? A completely made up word that doesn't exist besides in your mark or logo. Google, great example, Xerox. These are really strong trademarks because, one, they're probably not already out there if it's made up. You should check. We'll get into that in a second. But two, there's not going to be any confusion about it's merely describing the goods and services. So just remember, again, this is supposed to be a source identifier. How are people identifying your good and service from others? There can't be anything confusing in the marketplace. Again, also analyzing in the marketplace the mark in a similar class of goods and services. So you want to make sure that there is not a computer game, there's not a board game out there with a similar name, right? So the US Patent and Trademark Office will be reviewing similar marks in similar classes of goods and services. We'll get into what that clearance search looks like right now, actually. So the first thing you should do.
Sorry.
Yes.
Fiddling with the thing. The TV is not on your.
Yeah.
slides anymore.
Yeah, we've lost the slides.
Thank you for letting us know.
Hold for technical difficulties, folks.
It's not coming from us.
There we go.
All right.
Okay, trademark processes.
So good at technology.
Smart organizers here. So the
Yep,
first
blowing it.
and most important step in the process is the clearance. What clearance essentially means is you're checking the web, you're checking a bunch of different platforms just to make sure there is not someone that is using a similar or same mark in the same class of goods and services out in the world, right? And that's going to affect the territory, the specific. Is it a computer game? Is it a board game? Are they toys? So there are a couple ways to do an effective clearance search. First is where you're searching. That's going to be, you can start on the USPTO website. There's a trademark database. You can see what's already been applied for. You can search the class of goods services. Are these just computer games? Are they toys? Are they drilling machinery parts? I mean, these guys can tell you the class of goods and services are so granular, it's almost ridiculous. You can find anything on there. So if there's a likelihood that someone's going to be confused about a similar mark and a similar class of goods and services, probably want to avoid that. You can also just search on Google, search in Steam, search itch.io, any app stores, right? Anything that is kind of similar, you just want to kind of flag that there could be higher risk if you're using the same words, the same coloration, the same overall design and logo. And then as lawyers, we tend to use IP software that does a lot of this risk analysis ourselves. It can check very quickly to check different global databases, US databases, different class of goods and services, and it does clearance fairly quickly. So you can get a pretty accurate look at what the marketplace looks like for a particular term. So what happens if something's too similar, you find? Couple options. First thing is pivot, new name. And again, this is really tricky if you're really married to the game name, if you've already received funding, your audience already associates your studio name or a game name with a particular logo or a mark or a word. So that might not be the best case in some situations. Oops, I scrolled my bad. Okay. You can also attempt registration anyway if you're feeling a little risky and just see if the office will accept it and maybe it's a different class of goods and services. Again, not something that a lot of lawyers recommend because we tend to be very risk averse, but if you really love the name, then maybe it's worth a shot. You can also try to negotiate a coexistence agreement. If you are able to get in touch with the other mark holder that has a similar mark, maybe you can reach an agreement. Hey, you guys have TV shows in this class of goods and services for this name. We'll do video games, and we will make sure not to bother you guys in your area of focus. That's another way. Usually pretty rare. I'm not sure how often you're able to get those, but I've done one.
Oh, I've done a few.
Yeah.
It depends on the area of industry. It depends on what the interests are. It depends on, frankly, how nice their attorneys are.
Yes, that's a big one.
That's often the biggest factor. But
Yeah.
please
So
continue.
So again, an option, probably more of a last resort if you're, if you really want to use the name. All right. Again, most important step could lead to pretty legal, costly battles later down the road. We've seen the worst case scenario is when a name has been used in commerce, the studio loves it, the audience knows it, and then we find out that there is some conflicting use out there with the mark and they have prior rights. That's always a really bad situation for us to be in. So again, don't become married to the name if you can. Make sure you're doing a really effective clearance search earlier on. Okay, so we'll rush through this part because this is a little bit pedantic, but what does the actual formal registration process look like? You have to show actual use or intent to use. So actual use is, yeah, you're selling the game on Steam, right? People are able to buy the game on Steam. Intent to use is the product isn't really ready for launch yet, but you want to hold your place in line and you have every intention to make the good with the mark available to the public. So again, intent to use is a really good way to hold the place in line. If you're 2 to 3 years away from release, fine, maybe intent to use makes sense so that you really love that name, you can hold a place for yourself. What else will you need for the registration or the application? Pay some application fees. That's going to be $350 currently per class. If you want merch in addition to a game, that's another $350, right? If you want to use, if for a studio name, that's a video game development services, also another class of goods. So just keep that in mind when you're focusing your search of what you want to use the mark for. Also, another important note, just be really careful what information you put into the application. If you are a smaller studio, smaller developer, and you're using your home address, some of that information can become public. And I think the office has done a better job of trying to hide that, but some email addresses, I think phone numbers are usually public, so there are ways an attorney can help you get around that by using a registered agent, using enabling your attorney to essentially be the correspondent for address. So
Yeah, and also as soon as that information goes out, you can rely that there are going to be some scammers. They'll say, hey, we have this secondary registry. This is going to provide additional evidence. This is going to offer you protection in different ways. And it's,
And all you need to do is pay us $3,400
Yep.
and you're on there. Yeah, guys, the only trademark register you want to worry about is either the federal trademark register, the state trademark register in whatever state you reside in, or if you want to expand internationally, something like WIPO, the World Intellectual Property Organization. It varies depending on your needs, but if someone's coming out to you and saying, we actually have a private trademark register that we think your mark would be great on, just throw that email in the trash. Trust us.
yeah, and everybody that I've represented that has registered either a regular trademark or an intent to use, they immediately get several offers like that. And yeah, Ed's right. That should go directly to the trash.
or to your lawyer first, just to make sure, it's not an
That's
official,
also-
it's not an
Yeah.
office action that, from the government that you're throwing out.
And most attorneys aren't going to charge you to respond to an email and say, no,
Correct.
don't pay attention to that.
Yeah.
Unfortunately, reality, bad actors out there. So the last part, once, let's say everything's good, it's the application is submitted, it's a waiting game, right? I think the processing times are, 5 to 8 months? Is that accurate? It's pretty bad.
It varies.
It's been slipping.
It's gotten worse since COVID. Full disclosure, the USPTO has been experiencing backlogs ever since COVID, and they still haven't completely caught up. It's worse in some other countries. Canada is especially rough these days. And it has not been helped by a lot of recent job cuts at the USPTO.
Yeah.
We could say more, but it's not that kind of show, folks.
Yeah, and so just be mindful when you're receiving emails, if you have an attorney or someone else receiving emails for you from the PTO, just be careful. There could be an office action issued where the mark is not going to get registered without responding to an office action, and there are a multitude of reasons for those office actions. The most common is there's a likelihood of confusion, right? The government officials looking through their database and seeing, hey, there's something out there that kind of looks pretty similar, maybe in a similar class of goods and services. We're not going to grant your application until you address some of these concerns, right? So maybe they find something in the toy space. Maybe they find something in just general computer software that's a similar name, or it contains 2 out of the 3 words in your game's name. That could be something that gets flagged by the office that you would need to respond to. And that is a legal proceeding. That is, most times I would want an attorney responding to that, citing legal precedent just to ensure that all of the office's concerns are addressed.
Dirty secret about the registration context for trademark, copyright, everything we're going to be talking to you guys about. You can technically do all this yourself. You don't necessarily need an attorney. I shouldn't be saying that. We're lawyers who need clients.
Yeah.
You can technically do all of this without us, but when you're hit with a complex 2D refusal and you've got about 5 prior registrations with reasonably similar constructions to your trademark, and it's overcomeable, but it's very complex without the legal know-how, that's when you really should be thinking of reaching out to someone like us, because we might have a better chance of getting you guys past that hump and getting yourselves the federal registration that you need.
Yeah, it also helps to know exactly what category your products or services would fall into, though it also goes doubly for registering a copyright. That's a lot easier than doing a trademark. So unless there's a complicated issue, like you need to disclaim some very particular aspects of some AI generated aspect of your copyright, you should be able to do it on your own, watch a video or 2. Chances are it's not going to be where an attorney would bring a lot of value into the equation.
But we'll get there when we get to copyright.
Yeah.
All right, so I'll try to wrap up quickly here. I think we're getting up there. So just basically, trademark enforcement. You need to, when you own a mark, you need to be vigilant. You need to be mindful that there are other actors out there that unknowingly or knowingly might try to use the goodwill, right? That reputation associated with a word or a logo or a slogan of your company or your game to their own benefit, right? There might be an intent to confuse consumers, right? Right? You can throw Microsoft on your game and start selling a poorly made project, and that's not going to be a good thing for the mark holder. So just be mindful of that you should be, or having an attorney search constantly the web just to make sure that the mark is not being used. You see that a lot with like copycat games, right? Chinese copycat games on app stores, right? Just be really, really mindful. Maybe they'll use a word or two from the mark that you have to go out there and be vigilant yourself. There's also software that can assist with that, but it's up to the mark holder themselves. If there's a potential infringer, you see something that's a little too close to your mark, how do you handle it? A couple ways. If they're not openly trying to register, they're just kind of using the product out there, and they just have released a product or a service, right? Just reach out. You can reach out with a basic email or have an attorney prepare a cease and desist letter. Say, hey, we have this mark. Here's our registration. Here's our application. We think there might be a conflict, or request a takedown on the platform. You can do a combination of those. Usually people don't even know that they're potentially infringing, and they say, great, or they don't respond to you, and then you might have to take further action with an attorney's help. Two, if they're trying to register, the office may actually challenge the mark themselves. Like we said, they might issue an office action saying, hey, X studio has the first place in line here. Explain yourself. So they may do the work for you, but there's also a period of time where you can actually oppose a mark yourself when it's posted. So again, that goes into the whole area of vigilance and being mindful of what is going on in your marketplace. Okay, so this is another big question that we see is how to use others' marks in your work, right? Generally, it might be okay to incorporate real life marks and branding so long as there's artistic relevance to it and there's not an explicit misleading component of it, right? You don't want to call your game, Caverns, the Microsoft experience, right? Some people might associate that is coming from a particular source that is not Microsoft. So these are the kind of analyses that you have to be doing or consult an attorney for, just to make sure that there's no infringement. Again, attorneys risk averse. Sometimes it's just safer to change the name, right? You can parody the name. You could change it. Don't get married to the name if that's possible. Change a scene so it doesn't look like you're representing a particular building, area, person, what have you. Just be mindful that sometimes a pivot is the best.
I want to stress this point of Matt's too, right? Because like half of our jobs as attorneys is to assess risk and advise accordingly. 9 times out of 10, if you want to use a trademark in your own work, especially if it's a work that you are going to be charging for, something that is commercial, not something that is firmly in the category of fair use, although there's more on that later. 9 times out of 10, we're going to advise that you change the mark. Maybe do a play on Facebook instead of just doing Facebook. What was the like GTA 4 Twitter?
Oh, Playpen Pigpen?
Playpen or no. There's Twatter, I think it was. Like I don't remember, but
Life Invader?
yeah, Life Invader is another one. That's good. Thank you for the call out. I actually don't really play GTA. I'm sorry. Sorry, more of a Red Dead guy. But anyway, sorry. Please continue.
No, so that's exactly what Ed said, right? Sometimes it is easier in the long run to change, and your attorney may advise the same. So don't hate your attorney for suggesting that, okay?
Yeah. We don't want to stifle your creativity. We just want to make sure you don't get sued. Or if you do get sued, be in a good position to defend.
Absolutely. All right, so I think I'm going to hand it over to Ed
Oh,
now
that's
for
right.
copyright.
First off, let's give a quick hand to Matt. I think he's a great guy.
Thank you.
Thank you, Matt. All right. So we're moving into the second realm of what we call soft IP, soft intellectual property in the legal world. You've got trademark, that's kind of the more commercial leaning one. Then you've got copyright, that's kind of the more creative leaning one. They're both commercial, they're both creative. This is how I like to put them in buckets. So what is copyright? What are copyright rights? Copyright exists. It's not granted. In an original work to an author of that original work. Well, what kind of work? What does copyright protect? Creative expressions. Isn't that nice? Creative expressions. Sounds very kind of vivacious, sounds sort of artistically inspiring. Is it specific? Not really. A lot of things through the years have fallen under the category of creative expressions. Copyrights were originally crafted long time ago, centuries ago, initially to protect maps. Cartography was a big and booming business, especially as people started figuring out with more specificity what the world looked like. Over time, these cartographers were competing with each other, and they started noticing maps are getting ripped off. These are the events that led to the formation of the first copyright laws. Eventually, these were expanded to cover and protect things such as books. As media progressed, it got to photographs, and now we're debating whether or not something created by an artificial intelligence model could be protected under copyright law. The law is very much in flux on that, but yes and no. So, what does copyright not protect? Ideas, systems, anything that could be under the umbrella of a different area of intellectual property that we call patents. So, for example, the game board, the image of a game board for like Monopoly, that is something that can be protected. The rules of Monopoly, not necessarily. Actually, was there a case about that?
Monopoly specifically? I'm not sure about
No.
that.
Anyway, that's me tangenting. So, copyright protection can fall under a number of categories. Like trademark law, there is common law copyright protection. This gives you some protection over the works that you've created, whether that is artworks, an image, something in an audio visual recording, a video, a composition. But these are not going to be as robust as federal copyright protection, which is governed by the United States Copyright Office. Much like trademark law, you can file for federal copyright protection. In fact, if you ever want to sue for infringement of your copyright rights, you've got a bad actor out there who's knocking off your painting, then you have to actually file for copyright registration before you are allowed to bring suit in a court. But what does that get you? How long does a copyright registration live? How long do your rights to a work in a fixed medium live? Pretty long time. Unlike trademark, it's not potentially indefinite. Part of the idea of copyright law is it needs to have an expiration date so that people can innovate off of the works that have preceded them, right? The Renaissance wouldn't mean much if everything ever produced during the Renaissance was protected under copyright law to the benefit of the descendants of Leonardo da Vinci, for example. But you still get a lot of time. Generally, the period, the longest extent to which your rights to a copyright registration or common law rights can last are the life of the author who created the work, plus 70 years following their death. It gets a little more complicated than that, but that's sort of beyond the scope of what we're doing here. So, what are the key rights protected in under copyright law? If you have a photograph that you want to protect, what is a registration or common law rights? What are they enshrining your ability to do that other people cannot? Reproduce your work, create exact copies, distribute your work, put it out into the world for sale or just not for sale, just throwing artwork at people for free. I don't recommend that. To publicly perform a work, if it is the kind of work that can be performed. If you are a musician, then you have the right to perform your composition publicly. Other people do not necessarily. Again, some squishiness there, but publicly display your artwork. If you are a visual artist, you have the right to put your painting in a canvas and put it up on display. A gallery only gets to do that if you sign your rights or license your rights to do that to them. And most importantly for devs, most likely, create derivative works. If you have, what's a derivative work? If you, the example that's jumping to my brain is there was a big case regarding Seinfeld, the TV show Seinfeld. Someone created a book of kind of Seinfeld-isms that they never got a license from Jerry Seinfeld or the other creators who are who own it, probably the production studio that put it out. They never got the license to make a derivative work of the show Seinfeld, and so that was seen as an infringing work. It was seen as an infringing derivative work. But other examples can include video games based off of thing, toy based off of thing, other works based off of original thing. All right.
And just one caveat there, you see this a lot in publishing agreements, right? We'll get to the agreements and assignment in a second, but sequels, prequels, right? These are really important things to consider. So just be mindful of who has the rights to what when you're looking at an agreement.
So something I left a little vague in the prior slide, what exactly is a work that can qualify for copyright protection? Well, there are three main things that a work that is protectable under copyright law needs to have. One, needs to have a human author. This is big right now. Some of you may or may not be using AI for certain aspects of whatever you're developing. If you have feelings about that, I'm not here to tell you whether it's right or wrong. I am just here to tell you that for all of the fuzziness around how AI affects copyright rights at the moment, one thing that is pretty black letter at the moment is that a copyright will only protect works made by a human being. Okay, well, I put this prompt into an LLM. Is the resultant stuff protectable under copyright because I was the one who put in the prompt? No, not as it currently stands.
I've got like a slide on that.
For the prompts.
Yeah, it's the last one.
Yeah, as we're gonna, sorry, I jumped the gun. As we're gonna
No worries.
talk about, the prompt that you put in could be protectable. The resultant thing that you got out of the LLM, no, not necessarily. The work must be original. This may seem kind of self-evident, but no, you can't take some other person's book, kind of repackage into your own thing, and say that it's an original work. You might be able to be inspired by another work and then put in enough sufficient modicums of creativity yourself that it could be seen as its own original work. But that's all a part of an analysis that you really only want to worry about when you get to the infringement point. So, like, don't use the work of other people assuming that you're going to be fine because somewhere down the line someone will sue you and you'll be like, no, look at this thing, and this thing that makes my work sufficiently original. You don't want to get there in the first place. Just keep it original. And then finally, it needs to be fixed in a tangible medium. What's this mean? It could be fixed in a photograph, a physical, actual photograph. It could be fixed in a file for photographs, like a JPEG. It could be fixed in an MP4 file if it's a audiovisual work. Source code. This is especially relevant to you guys. Not all of the code you write for game dev is going to be protectable under copyright. Not all of the systems you create in your work are going to be protectable, but your source code, we have black letter law that says that that is protectable. So keep that close. Federal registration, it requires a formal application to the U.S. Copyright Office, much like trademark work law involves. It requires a filing fee. All of these filings require the payment of fees. Thankfully, copyright is pretty cheap. Standard applications start at around $65. There are some cheaper applications you can do for very niche circumstances, but generally it is $65 and up for a single work. It requires a deposit or a copy of your work that the U.S. Copyright Office can hold on to and deposit into the Library of Congress, where it will be preserved for posterity and for the furthering of the useful arts. And it requires a complete application, either filed digitally or on paper. Paper applications are more expensive. You're probably not going to do that anyway. Just go digital. It's cheaper, it's faster, it's easier. If all goes smoothly, copyright applications tend to be a lot quicker than trademark applications. You can go from application to registration, if all goes well, with no hitches, no office actions, no objections, in about 2 to 4 months. So if you've got something that you've got fixed in a tangible medium, even if it's just an image that you think could turn into a really great game someday, may behoove you to just go ahead, pay $65, file that thing now, see if you can get a registration for this image that might turn into a really great game idea one day. Of any of the IP rights, I always recommend people be like the most cavalier with trying to get something registered under copyright because the barrier is so low. Yeah, okay, moving on. We have a little chart here that kind of designate what sorts of rights fall under which bucket between copyright and trademark. people who are not kind of obsessed with this stuff like we are will sometimes use the two interchangeably. They are not. Like Matt said, think of trademarks largely as branding. Think of copyright largely as kind of the creative essence of whatever it is that you're putting out there, the art itself, perhaps. So under copyright could be anything from the music that you make for your game, the source code itself, elements of the story and the narrative, but it depends. Like story ideas, ideas are not protectable under copyright. If it is something called a scène affaire, which we're going to talk about in the next slide, it's not protectable under copyright. Advertisement and marketing copy, anything that resembles something like art or original writing, that is protectable. Packaging, box art also falls under that bucket, but the kind of shape of the box itself, if you, way far ahead, sorry, if you've decided that you're going to release your game code in like a little piece of paper that's inside a cylinder that looks like a can of Nuka-Cola or something, that's going to fall under trade dress, which is in trademark. Characters, lore, setting, all of these original elements are things that could be protectable, but again, it depends. Sometimes things get to a level of like genericism or kind of broad ideas to the point where it's not considered sufficiently original to constitute a work that is protectable under copyright. Platform and web design are pretty unambiguously protectable as well. But like Matt said, trademark, the name of your game or a series of games, more specifically, would apply. Your studio's name, your publisher, if you are a publisher, your name would apply under trademark. Catchphrases, slogans that are associated with a certain game or character or what have you, logos, packaging, like I said, trade dress, all of that applies.
Try to wrap up in like
I'm talking too much. Let's get it. So, like we said, some of this is review. Copyright protects original works of authorship, and often, or more accurately, their very distinctive elements. It can include unique characters and storyline elements. An example of this in law is the Batmobile. The Batmobile was considered something that was sufficiently distinct to be protectable under copyright. It needs to not fall under the category we refer to as scènes affaire, a French thing that refers to an idea or a trope that is so generic that is considered almost required within a certain genre. So like think of a fedora wearing, whiskey swilling noir detective sitting in a shadowy room with cigarette smoke flying all around, and then a beautiful but dangerous lady walks in with a job. That's not a scenario that's going to be protectable under copyright. That is a pretty typical run-of-the-mill noir scenario. It's going to be considered a scène affaire. But on the other hand, in a case called DC Vital, the Batmobile was considered to be distinct enough to be considered to have enough indicators of originality and specificity that it was protectable under copyright. So, what about if you want to assert your ownership over something? How do you know whether or not you actually did own something if you made a work in connection with other entities, another studio, maybe you've partnered with someone but have since gone their separate ways? This is where copyright assignments play into things. If you get together and you shake hands with someone and say, okay, we own this 50-50. Sometimes a handshake deal can be enforceable, but you never want to rely on a handshake deal. You want to get this down in paper. These are types of contracts called assignments. You can assign any number of rights that fall within the copyright bundle to another person, to your company, whatever entity you want ownership in. But it needs to be on paper. Ideally. Like I said, handshake deals can apply, but don't rely on those. Get someone to write a contract yourself, whatever the case may be. Work for hire, works made for hire. This is significant, guys. Are all of you self-employed? Do some of you work for a company, a broader game dev studio? Then anything you make within that studio might be a work made for hire. That image that you've made, that piece of concept art, that might not necessarily be yours. Depending on what your employment contract looks like, that is made under the auspices or within the scope of your employment, and therefore it is owned by the governing employer.
We got like 8 minutes left.
I'm going to just skip ahead a little because I'm talking too much. Like I said, if you have work as an employee, then chances are, depending on what your employment agreement looks like, what you make might not be something you own. This can also apply to situations of joint authorship. Whenever you are making something 50-50, like I said, get in a contract. Otherwise, the questions of who owns what part of what you made may lead to a lot of trouble down the road. All right, things to clarify in a collaboration agreement. Collaboration agreements, or really any kind of agreement that set out the guidelines of who owns what in a thing, in a work that you are making together. You want the scope of the work done. What was your job? What was their job? Did all of you stay within your respective zones? Okay, then that's neat and pat and ready to go. The relationship of who of different people within the collaboration. Are you partners? Is one of you the employee to the other employer? Are you an independent contractor? All of these can affect your rights. Use of aspects of your right of publicity, such as your photograph, your name. Do you have to perform all of the work? Can you subcontract it, outsource it? All of these are things you want laid out word for word in an agreement in an ideal scenario. Now I'm going to hand it over to Ryan to discuss
All
fair
right.
use.
Yeah, so fair use. Now, fair use. Oh, good job, Ed.
Thanks, guys.
Fair use, real quick. If you shoot at the king, you best not miss. What this means is that fair use is actually an affirmative defense. That means that you're making it when you're being sued, essentially, or you're at least using the leverage of your case to avoid being sued. However, what is or isn't fair use can differ from individual to individual or from judge to judge. Now, there's a 4-factor analysis of what is or isn't fair use. The first factor is purpose and character of the use, which is to say, is it nonprofit or for-profit? And often the most important question in the entire analysis is it transformative? That means, have you changed it enough to kind of make it your own? Then there's the nature of the copyrighted work. For example, is it factual or is it imaginative? A phone book does qualify for copyright protection because of the arrangement, even though it's the facts. And those facts, you can pull it out and you can put it into a different arrangement because it's factual. They can't say, hey, you took our copyright, unless you're also taking the arrangement, the way in which it is ordered and organized. That's known as arrangement copyright. Then there's the amount and substantiality of the portion used. Sometimes you take very little, but you take the beating heart of what is really original about that entire work. Say the entire work is scenes à faire, except for one aspect. You take that one aspect, you have a very strong case against you, though it will often depend. And reasonable minds can disagree, which is why copyright and trademark attorneys often like to say, it depends, because it's going to depend on the facts as well as the decision maker, which is typically the judge in that scenario. Then there is the market effect on the copyrighted work. Now, I found that arguments about that, it really varies. For example, the television show Game of Thrones, if that wasn't licensed, you would still say that George R.R. Martin sold more books because of that TV show, even though if they didn't have the license for it, it very much would have been copyright infringement, most likely, depending upon the judge. So that factor, I actually find that's typically in flux in modern arguments because of interconnected media. But again, it depends. Now, my apologies for blowing through this so quickly. Satire versus parody. Parody is a particular subset of satire that is typically safer. For satire, you're using X to make fun of not necessarily X. For parody, you're using X to make fun of X. So I take a version of Bart Simpson to make fun of Bart Simpson. That is specifically parody. I take a version of Bart Simpson to make fun of something else. That's satire, and it has a bit less protection because you necessarily have to take from a material to make a statement on the material. If it's not limited to that material, then you could have taken from a broader range of properties to make that statement. And so because you weren't in the straitjacket of taking from that particular property, there's more of an argument of the artist who owns that property saying, hey, you could have taken from anywhere. You didn't have to take my stuff, man. All right, so moving on to AI and copyright, which we touched on before. If now the Copyright Office came out in, I believe, November of last year with some guidance. So we're going to kind of try to keep it mostly to what they were saying. Now, if you take a prompt to generate an image, that the prompt is probably copyrighted, but the image absolutely is not. If you take an image and you put it through to make another image in the AI generated image, the first image, so long as it ordinarily qualifies for copyright, meaning that is a work of original authorship, is an original work of human authorship, then it would qualify for copyright. And the part of that image that is in the final product that the AI spits out, that that portion of the AI image that would be recognizable as that original image would be copyrighted. So it gets a bit complicated because there is an element of the final image that is going to be copyrighted, or at least a copyrightable element, even though the whole isn't necessarily a copyrighted work, or, well, it isn't a copyrighted work, that particular element is. So we're getting into a fuzzy, nebulous aspect that really hasn't been defined at a high level. We might find some circuit decisions or, some district court decisions, but there hasn't been a Supreme Court decision yet. So the most that we have to go off of is the Copyright Office guidance. Now, there was a Supreme Court decision, which is still, unfortunately, the most on-point decision, the Burrow-Giles Lithograph Company v. Cerrone. Cerrone took a photograph, which is a mechanically assisted artistic work. Now, once you click the shutter, it goes through a mechanical and chemical process that is completely removed from human creativity beyond what you were setting up. So there's a lot of artistic input into the setup of the photograph, shutter speed, lighting, if you have a model, the wardrobe and posing, there's a whole lot of creativity in photography, but once you snap that shutter, whether it's a digital process or a mechanical and chemical process, it is removed from the original creativity. Now, in this Supreme Court case, it was decided that there is enough creativity that goes into setting up the photograph that the final result does qualify for copyright. That's why photographs are protected by copyright. However, if you take away that original setup of the photograph, at that point you have only a mechanical process that has no human input. And the Supreme Court decided that in and of itself, if you didn't have that original photographer setting things up, that wouldn't qualify. For example, there was the Naruto case in the Ninth Circuit where a monkey took a selfie. That doesn't qualify for copyright because it's not human authorship. And that would be, within the basic gist of that Supreme Court decision. Now, this gets really fuzzy and really nebulous very quickly. And so what I'm saying right now might be outdated in a month or two if a circuit court decides to take on this case, or if the Supreme Court, please take it, decides to take the case. And at this point, I'd like to get a little input from...
I mean, there have been some pretty informative cases. There is this one guy. He is a I don't know exactly what his area of expertise is, but he's made a number of AI models throughout the past decade and change, since before the AI boom that we've been experiencing since 2022-ish, or whenever you want to start tolling that. He has been working for a long time to try to register with the U.S. Copyright Office AI generated images. As far back as I think 2008, he's been working on this. He's yet to succeed, which goes to show how seriously courts are taking this idea of human authorship as a necessary element of copyright protection.
Really quickly,
Do you
I
have that?
the image from the copyright guidance if you want to run with
Oh,
that.
cool. Yeah, this is not this guy's image. His image is way worse because he's working with a model that is effectively 10 plus years old. But it goes to show how seriously courts take this element of human authorship. So be wary about what you want to be using AI for in the development of your game. If you need have something specific in mind, a specific element of your game that you want protection in, you may be hurting your ability to obtain and then enforce your rights to that thing if you are overusing AI in the development of it. But like Ryan said, this is very much a developing area of law. Pretty much pretty much everything most copyright attorneys are talking about right now are the implications of artificial intelligence in copyright law. So more on this space as it develops.
Are there platform specific bans still? I think Steam has like vacillated a little bit about what they allow. I know.
No.
I think they do require you to affirmatively say yes or no that AI has been used.
I can say from personal
There's a disclosure, yes.
I'm not.
Okay.
Yeah. I'm not too sure, but the image that you guys are seeing, on the left is the input, on the right is the output. On the left, like comparing those images, the image on the left is copyrightable, and the recognizable elements of that image on the left, on the image in the right, those are copyrightable or copyrighted elements, which means that if you took the output and you took certain aspects of the output that don't have elements of the image on the left, that's safe.
Yeah, and let's be specific about that, right? So, what are we talking about when we're talking about the copyright elements in the image on the right, right? We're talking about maybe these cheekbone lines.
Yeah.
We're talking about the shape of the lips in this face, the fact that there are 3 rose stems sticking out of these specific areas on the face, not 4, not 5, not 2, but 3. These are the kinds of very specific design elements that people are looking for when they're looking for the copyrightable elements of a work that is otherwise not copyrightable in its totality. And it's not just AI that is subject to this analysis. It is commonly referred to as kind of a filtering process, any process of determining what elements of a work are copyrightable and what elements aren't. Even things like code have been subject to this filtering analysis. Look up the Oracle Google lawsuit that was ongoing for years and years and years if you want more information about that. That was, to a large degree, what was involved in that case.
Yeah, and so you can see that there are elements of the as Ed was saying, of the image on the left that are in the image on the right, but the shading wasn't included in that original image, and so
Color.
yeah, the color, certain aspects of the lines were enhanced, so those enhancements, but really what would be copyrightable about the output and what wouldn't be, reasonable minds can differ, which means that reasonable judges could differ, and you don't want to wind up in court making an argument where a judge might side with you, might not, but will probably be right in either case because there just isn't enough case law and there isn't enough guidance from Congress right now.
And just in general, don't roll the dice, whether with AI or anything, thinking to yourself, well, it'll get worked out in court. If you find yourself in court, then something's already gone pretty wrong.
Yeah, and again, fair use is an affirmative defense, which
Yeah.
means you're already in trouble.
Yeah.
You can use like the threat of using fair use to try to avoid going to court. But even at that point, it's like, okay, this guy's pissed off at me. I gotta make it clear that I would win on a fair use argument. But at that point, he might hire some attorneys. I might get dragged into court, and I'm on the back foot already.
I used to get yelled at when I was a younger attorney about partners whenever I would draft an email advising a client saying, well, it looks like a fair use to me. He'd always say, fair use only applies when you're already being sued. Don't advise clients about fair use unless they are being sued. It is our job to guide them in a direction that lets them avoid being sued. So that's how lawyers think of this. Knowing about fair use is useful because it can, for you as creatives, guide your decisions in terms of what you want to make and how you want to make it so that you can protect yourself. But in general, don't try to design something and think to yourself, well, it's probably a fair use because of this, this, and this element, because the court might end up disagreeing with you, and then you're in a shitty situation.
Yeah, and these questions get very complicated. Attorneys find them very confusing. If you're getting confused, I mean, I could do a 5-hour long presentation on fair use alone, and you guys would still walk away scratching your head because that's what I do every time I read a Supreme Court decision that implicates fair use. Like, okay, there aren't hard lines, and that's necessarily because there needs to be some room for creativity. But those blurred lines to allow creativity in some contexts but not allow it in others create a lot of confusion that the district courts, the lower courts, before you get into multiple appeals processes, wind up having to deal with. And yeah, you're not going to want to pay an attorney for your defense. And then if you lose, you're not going to want to pay another attorney maybe even more money for an appeal, and then another for another appeal, and see how high you can take it. It gets really expensive really quick. It gets really confusing really quick. And staying on the safe side is generally a good idea, but again, that's a very fact-intensive analysis that each individual makes.
Are we over? I can see we're about 10 minutes over.
I mean, you guys, if you have any final thoughts or anything that's personally
Final thoughts. Artificial intelligence is essentially a frontier, not only in creativity, but also in law. You're going to see a lot of rules develop. You're going to see a lot of what we're saying outdated, hopefully within the next few months. The Copyright Office came out with guidance in November of last year. I'm not sure when the next guidance is going to come out. I would highly recommend reading it for your own clarity because we haven't had enough time to go through all of it.
Anything, Matt?
Yeah, I just a related issue, right, is licensing as well. If I see this all the time, right? Oh, I paid for assets, right? I paid for assets. That means it's safe. They're not AI generated. You need to have the proper license for the proper usage. If you do not have the proper license with the asset creator, you cannot use that in a particular project, right? It's the same. The idea is if you're using a game engine that's free for your educational use, for portfolio use, and that's it, and then trying to sell the game, right? Trying to sell 1 million copies on Steam. That you need to be extremely careful what you have the right to do. And what you have authorship of. So just be really, really careful what you're licensing.
That would be in terms of service, right?
It could be like in a deal sheet that
Yeah.
you've agreed to with an order form. I'm not sure what process.
It depends on the variables, but I want to emphasize that point by Matt because that's very important. Intellectual property is a body of law that deals in property, just like real property, the house you own. None of us own houses. Some of us might own houses. I don't want to put that on you. But just like intellectual property deals in property that is of the mind, hence the name. It is not usually something physical. Sometimes it is, not always. Just like property law, just like physical property, you're not dealing with individual rights here. You're dealing with a bundle of rights that fall under an umbrella. So, like what Matt was saying, if it's subject to terms and conditions, if it's subject to a license that you are the licensee of, the rights that are being conveyed to you in that legal instrument, in that document, may not encompass the totality of the rights that the owner has available to them. So just because you have a license to do one thing with whatever assets you are given rights to does not mean you have the right to do all of the things you want to do with those assets. So make sure you read these documents carefully. I know there's a stereotype around no one reading T and C's, but it's an important thing to either do yourself or have a lawyer do.
Because they're happy to do it. They love
Because
it.
yeah,
Love it.
we love it, especially if we're getting paid to do it. So.
Yeah, and all of us could go on for a very long time on basically any one of these topics, and we're all going to be available for a bit after this.
Please ask us questions. So much of what we just talked about is really difficult to digest from a 40-minute PowerPoint.
Yeah.
All right.